Welcome to the next chapter with Denise Young and special guest Philippe Richer from TLR Law Office. Today we're going to talk about all the things you need to know about listing an estate style home. How are you today?
I'm well, Denise. How are you?
Good.
Good.
And, can you tell us a bit about yourself so that we know why we're chatting about this today?
Sure. I'd be happy. So as I said, my name is Philippe Richer. I'm a lawyer. I have an office in St. Boniface. We also have an office on Scurfield and an office in the courts of St. James. So we have three offices. We offer legal services in the areas of real estate conveyance. So that's buying and selling a house, which is what we're going to be talking about today.
Yeah.
We also offer services in the areas of estate planning, so making wills and powers of attorney, which we will also talk about today.
Yes.
And we also provide services in estate administration, which is once somebody passes and we apply for letters of probate or letters of administration, which is also something we're going to talk about today. And then finally, we offer services in the corporate commercial world, which we likely won't talk about today.
Probably won't come up.
Yeah.
Awesome.
So my journey as a lawyer is a little different than most. I came to law much later in life. I went to law school in my late 30s, and I was called to the bar at 41.
Wow.
And I've been a lawyer now for 15 years, so that tells you how old I am. And prior to law, I was at 17, I joined the Army. I did 8 years with them. And then from there, I went into sales, and I sold real estate for 4 years out in Brandon, which is what we're going to talk about today.
Yeah, exactly.
And then I ended up in the industrial equipment business, forklifts. And I did that for Johnson Equipment and then Toromont Cat. I worked for them. And then I went through a divorce, and that's, following the divorce, I had to start over again. And I thought, well, if I'm going to start over, I'm going to do it on my own terms. So I went back to school. And
that's awesome.
Yeah, it was the best post-divorce therapy I could have ever asked for.
That's interesting. We might have to talk about that another day, because that is something we talk about a lot on my podcast, is divorce.
Oh yeah. Well, it was going back to school was really the best thing that I could have done. I had an absolute blast in law school.
Oh, that's good.
And in fact, that's where I met my spouse, Cheryl. Yeah, who's also my business partner. So she's also a lawyer. We met in law school, and so law school was a big turning point in my life. Yeah.
Right. Yeah. We often talk about divorce. It's kind of like why my podcast is called The Next Chapter. Is it has a lot to do with starting over.
Yeah. Oh, I've done it.
Yeah. Okay, so let's talk about the difference between an estate sale and a power of attorney sale.
Well, okay. So a power of attorney. So we do a lot of power of attorneys. We do a lot of wills. We do a lot of power of attorneys. We probably do between the three offices. We have between about 500 matters a year that we open on that topic, and oftentimes, more than often than not, it's a couple. So we probably do 700-800 POAs, powers of attorney, a year, as well as wills. So powers of attorney, everybody's heard of it, but oftentimes they're not entirely clear what that means. So a power of attorney is somebody that you appoint under a document called the power of attorney, and there's an act under the legislature of Manitoba. It's called the Power of Attorney Act. So very clever name for the document. Yeah. And that act allows you to appoint somebody to manage your legal affairs in the event that you're not able to do it. Now, there are several types of powers of attorney, and we can talk about that maybe a little bit later. But a power of attorney, essentially, you're giving somebody else the power while you're still alive, and that's the important part, to sign documents on your behalf. And some of those documents include, of course, offers to purchase real estate, as well as transfer documents, which are the documents that you sign when you're close to possession date and you're meeting with the lawyer, and to transfer the title out of the name of the person who's on title, which is the person who appointed you as power of attorney, to the buyers. Because that's typically when it's rare that a power of attorney will act for a buyer.
Right.
It's usually when they're selling, and it's usually an elderly couple that maybe they're suffering from dementia, or they have mobility problems, or they're just too old, and so the power of attorney will often step in.
Right.
Typically the kids, not always, but typically the kids will act as the power of attorney, and then will help mom and dad by meeting the lawyer and signing all the documents on behalf of their ailing parent.
Right. Right.
So that's the power of attorney.
Yeah.
So the power of attorney would act when elderly people are still alive, maybe not fully competent, maybe competent, but mobility issues, and then they'd be acting on their behalf.
Right.
In an estate situation, it's because somebody's passed. So when somebody is passed, and oftentimes they own real estate, and then so that house will go on the market, and it is the estate that ends up selling because the house is in the estate, is owned by the estate. So the estate, if you think about it as a person, is it's a legal entity. It's not a real person because it doesn't exist as a real person because the person is passed.
Yeah.
So it's a trust, and the trust is the estate. The estate owns the house, and the executor or the administrator are the people who are authorized to act on behalf of the estate.
Right. And what needs to be legally in place before a home can be listed for sale in an estate situation?
Yeah. So this is where probate is required. So if you own real estate, if the deceased owns real estate, then letters of probate are required because the property registry, that's the organization that actually controls the titles.
Yeah.
So we're in a Torrent system, and I'm sure you've talked about this before. We're in a Torrent systems. The titles of the house are held at the property registry, and that the property registry has offices all over the province, with the main one being downtown Winnipeg.
Right.
And the title of your house is there, and the title is the document that proves who the owner of the property is.
Yeah.
Now, for the older generation that like those old westerns, I got in fact, you know what? I think I've got an old title here.
Yeah. They'd run around with them in their hands.
Yeah. I've got my title under the mattress. You're gonna have to kill me to get my title. Right? So,
I think my dad did that recently.
so
Yeah.
This is what the titles used to look like.
Right.
Right. So those of you listening on Spotify, ship over to YouTube so you can see.
Yeah.
But I love these old documents. Look at that. Isn't that beautiful?
Yeah. It does look awesome. Yeah.
Why don't we do things like this anymore?
I don't know.
Because titles today are very boring looking.
They're very boring. Yeah. They're not very exciting to get the title of your house anymore. No. Yeah. So the property registry won't allow a transfer of title without letters of probate or letters of administration, and we can talk about in a couple of minutes if you want about the difference between those two. But essentially, yeah, that's it. I probably talked too much here. No, that's good. That's good. So how long does probate usually take, and what can delay it?
Yeah, so there's a couple of things. There's a couple of spots for delay in getting letters of probate. First of all, you need all the information required to apply for letters of probate. So it's an application process. So it's a court process. There are forms that are prescribed by the court that we have to complete, and those forms require a certain amount of information. So if we don't have all that information, and it takes a while to get that information, that's a delay. So that's a delay that could be because the executor or the administrator can't find the stuff because the deceased wasn't very well organized, or it's not a close person, somebody who's close, and they come in and they're trying to figure out what's going on. Maybe it's a surprise, like somebody died suddenly, and there was no planning involved. So then they have to put on their like Sherlock Holmes hat and try to figure out where the bank accounts are, where, so that can create delays, quite a bit of delay actually in some cases, because it's really hard to get that information with the privacy laws we have today.
I guess so, yeah.
And ironically, the banks, when you're asking them for information, say, well, do you have letters of probate? And like, no, I do not have letters of probate. I'm trying to get letters of probate, and I can't apply for letters of probate until you give me this information. Well, I can't give you this information until you get letters of probate.
That's
right. That's how I hear them.
Yeah.
So I always have to go through this little song and dance with the banks and say, look, this is what we're doing. We
Yeah.
need this information so we can. So there's that delay at the front end. And then once we have everything in place and the application and we file it, then it's another anywhere from it could be 4 to 12 weeks. It's been 12 weeks in the past, but it's been a while since it's been 12 weeks. It's
Oh, yeah.
probably 4 to 6 weeks right now, I would say.
Oh, that's good to know.
Yeah. Yeah. Let me see. I just got one back here from Probate. When did I file? March 10th. Yeah. So
Okay.
maybe 5, 6 weeks.
That's not too bad. I know, like I have clients that have been told that it'll likely be 12 weeks. So like, I feel like we're preparing people for the worst, right?
Yeah, well, and
Yeah.
you hope for the best, but you
Yeah,
prepare for the worst, right? Because
exactly.
it has taken up to 12 weeks in the past.
Right.
Like we haven't seen that in a while, but because that, and you cannot transfer title until that happens. So if you have a possession date
Yeah.
that is too early and titled and we don't have the grant of probate, then you're putting your clients in breach of contract because
Yes.
they physically or legally cannot actually do the thing that they promised to do in the offer, which is give them possession of the property on a certain date. So
Yeah.
without those letters of probate, that's not going to happen. So it creates problems,
Yeah.
and
And I
it's
know I'm seeing some people list houses without probate, but MSC actually doesn't want us to be, right?
yeah
And I advise my clients, like, why would we do that? And then we're having to only market to people who have flexible possession, because what if it takes longer to get probate? And we have seen so many instances where probate takes longer. And sometimes probate gets sent back and has to be redone or because of, the wrong dot was put somewhere.
yep
Is that picky. So I always say, like, it's best to wait until we have probate done because then our buyer pool is bigger, right?
Yeah. Oh,
So
for sure.
yeah.
And it was my understanding too that under the new regime and the new offer that the Manitoba Securities Commission wouldn't be allowing that to happen.
Yeah.
So
Yeah.
is it barred,
It
banned, or is it discouraged?
it is discouraged.
Okay.
There is not an official rule against it, but they strongly discourage it.
Yeah. Yeah.
Because of all the complications that can occur. And I think that, the more, like, MSC is very complaint driven, right? So I think that if they got more complaints about possessions being moved or what have you, it likely will get barred eventually. But
Yeah. Yeah.
yeah,
Yeah. I usually tell my clients to wait until probate issues. I
yeah,
mean, I suppose you can always make the argument that, like, it's a really hot market right now and there's going to be a lot of people, and if it falls within, maybe, like, there are some considerations outside of the legal consideration that people should take into account, right? Because I mean the markets are strong now, but nobody has a crystal ball. We can't
yep,
tell if 6 months from now the market will be the same, and
exactly.
and so maybe it's to their advantage of, in a really hot market, to put it on the market even if you don't have the letters of probate. And
Yeah,
if you do that, and it's not an unreasonable position to take, you just want to be really careful about what kind of conditions you put in the offer to protect you from being in breach of contract.
exactly.
Yeah,
Exactly.
yeah. And I think most realtors understand that. And
Yeah.
when I usually tell my clients, just put your realtor in touch with me. I'll give them the wording for the
Mhm.
condition that I want,
Perfect. Yeah.
and then the realtor, when they're drafting the offer with the client, will just put in that clause into the conditions, and then that is usually sufficient to protect the parties.
Right. Yeah. No, that's perfect. And it's always wonderful as a realtor to have a lawyer who's working on, like,
Yeah,
willing to have that chat with us before we list. Because every lawyer who does that process, I won't say every lawyer does it differently, but everyone has the way they want it written, right?
yeah,
Like,
yeah,
just like every realtor will write different clauses differently, right?
yeah,
So,
yeah.
so yeah, I like to be on board with whatever the lawyer that my client is using wants to have it worded.
Yeah, that's a good point. In fact, to me, the most successful deals are the ones where the realtors and the lawyers work hand in hand.
Yeah, instead
Yeah,
of me forcing what I want to do on you, and
yeah, or
Vice-
vice versa, which I know
right.
happens a lot with
Yeah, let's
lawyers.
chat about it.
Yeah, yeah,
Yeah, and sometimes, like you said, the market shifts and stuff like that, and sometimes there is things that might be advantageous, like I don't like to list before probate is, but you're right, like, yeah, sometimes there might be a reason why we should. And so, like, I'm not saying I never would, I'm just saying I would prefer not to.
yeah. I mean, everything being all else being equal, you're better
Yeah,
waiting, because you're absolutely right. From a marketing point of view and a larger pool of buyers, you'll get more money for a property than if it's not. But if you're in a really hot market and somebody's worried about interest rates and the world the way it is today, it's kind of
yeah,
chaotic, and you don't know, right? Like,
yeah.
I
I mean,
understand there was a country once where they had tulip bulbs that were really expensive for a period of time, and everybody thought that would last forever. And
right.
so,
We had such an insane January that, like, houses that even had foundation issues were selling well above asking this year, right? Like, so,
no.
like, yes, if you had a house that was going to be questionable in January, you probably should have listed it.
Right.
Yeah. Yeah. Anyway, um, so let's see here. Um,
We
and
we did talk
yeah,
briefly about I did talk briefly about letters of administration and letters of probate. Did you want, maybe we should just cover some of that, what
let's
the
back
difference
up to
is?
that. Yeah, yeah, let's do that.
Okay, so um, if somebody drafts a will and they appoint an executor under the will, and that executor is alive and willing to act, or the alternate executor is alive and willing to act,
Yeah,
then they apply for letters of probate. Okay, so that's what the court will issue, letters of probate. That is a court order. So okay, so
yeah,
it's a pretty simple looking document. It's one paragraph that says so and so is appointed as executor for the estate of so and so, effective this date. Okay, and then you'll have the seal of the court on there, and then they'll put a copy of the will there.
right,
Okay, and that's all one document, and then that's all sealed with the court seal and signed off. And so that document is the legal document, is the court order, is the passport of the executor that proves that the executor is the person named, that the executor now has the authority to do what they need to do. So as lawyers, when
yeah,
we're doing a transfer of a title, we need to get a copy of the original grant of probate.
right,
If somebody dies without a will, or if they have a will, but the executor that they named and the alternate executor that they named have passed or are not willing to act, then you don't apply for letters of probate. You apply for letters of administration.
right,
Now, it's the same idea. And if there is a will and it's the question of the executors are no longer available, then it's letters of administration with will attached. Okay, so same idea. You get the certificate that says letters of administration with the will attached to it, court seal. If there's no will at all, then it's the letters of administration, which is a single page or 2 pages, and it's stamped by the court, and it says so and so is now appointed as administrator for the estate.
right,
For practical purposes, it does the same thing.
right,
Okay, it's the same idea. It's just one has a will and the other one there is no will, or
right,
there's no executor with a will attached. Okay, there are some differences, and maybe the biggest difference for our purpose is that under letters of administration, if there is no will and the person owns assets, including a house, the Intestate Succession Act of Manitoba dictates how those assets are going to be distributed. So let's use an example.
yeah,
Let's say there are 3 adult children, and the person who passed is the widower. Okay, and the 3 adult children are alive. So in that situation, the widower passes without a will. The 3 adult children are entitled to receive the estate, the inheritance. Okay,
okay,
so one of those 3 kids should apply, as long as they live in Manitoba, should apply for letters of administration. They cannot sell the house unless all 3 agree to selling the house.
okay,
So if one of them, let's say there's a dispute, they don't get along, these are siblings that just hate each other.
yeah,
One of them wants the house, or 2 of them want the house. and they don't think the third one should get anything. The one who applied for letters of administration now. So the only thing they can do without anybody's consent is to transfer the title to all three of them, which is not a good idea because now you have three people either as joint tenants or tenants in common on the same title. They don't like each other. It's really hard to make decisions about that. So they need to have they need to have everybody agree to sell the house. So if one of them doesn't agree to sell the house, technically you can't sell the house, or not technically, legally you can't sell the house.
Yes. And that can create other complications because who's like paying the bills and right? Like,
well, so the administrator, the one with the court order, would be the one responsible for paying the bills.
right.
Right. But who wants to apply for letters of administration when your siblings are
Yeah.
so there are so it's a little more complicated. It can be a little more complicated with letters of administration. With a grant of probate and a proper will in place, then you give the instructions of what you want to happen, and the executor has all the power in the world to sell the house. They don't need to worry so much about the kids. We even in that we still get consents for the sale of the house, just to be safe.
Sure.
But the executor, there's an argument to say that the executor has the power to do it.
Right. They have the power to do it, but they also have responsibilities to the beneficiaries, right?
Yeah. Yeah, because they're trustees.
Yeah.
Yeah.
Do you want to talk about what that would be?
The responsibility to the trustees?
Yeah.
Or the trustee's responsibility? Yeah. So a will creates a trust, and the executor is the trustee. So you often see that in a will, executor and trustee. So the will is the executor is the trustee, and then the people who inherit the money are the beneficiaries, right? And so typically in a typical family situation, in the wills, mom gives everything to dad. If dad predeceases, it goes to the kids in equal shares, and vice versa. So if you use, and when the second one of the parent passes, then typically it's one of the kids or a couple of the kids or all the kids that are the executors.
Right.
And then the beneficiaries are, in this case, if the will dictates, it goes to the children in equal shares. So the child who's an executor is also a beneficiary.
Right.
That's not a problem, even though there's an inherent conflict of interest there. It's not a problem. We do it all the time.
Yeah.
So you have the child who's the executor, and then you have his or her siblings that are the beneficiaries. So that person, as the trustee, has legal obligations towards the beneficiaries to act in their best interests. So they can't really. Now, there are often arguments about what amounts to best interests, right?
Right.
And the arguments that what the law considers best interests and what individuals may consider as their best interests is very different.
Right.
The law allows for a lot more variety in that, whereas you're pretty specific about what your interests are. But you can't. So an executor should act in a reasonable way. But that doesn't mean that the executor has to sell the house within 6 months.
Right.
The law will allow way more leeway to an executor than that, like probably a couple of years, even though everybody else thinks that's unreasonable. So there is a lot of leeway in that. Yeah. And typically wills will have a lot of powers that are given to the executor that allow them that give them some flexibility, because you want to find that nice middle part.
Yeah.
Where it's not so onerous on the executor that if they don't do everything exactly the way, like at the earliest time possible in the best possible way, that they end up being liable. So we don't want to create that situation.
Right.
And at the same time, you don't want an executive who's lazy or has ill intents to, become an obstacle to the beneficiaries receiving their shares.
Right. Is there like other tax implications for the executor?
The executor is responsible for paying the taxes of the deceased.
Mm-hmm.
So when somebody dies, the Income Tax Act of Canada creates a deemed disposition. So that's fancy words for saying, as far as the tax code is concerned, once the person passes, they sell everything they own at fair market value, and they sell it I'm using quotation marks for the people who can't see. When they
Yeah.
sell it, in quotations, they're
Yeah.
selling it to the estate. Okay, so there's
Right.
there's a legal change in ownership from the deceased to the estate.
Yeah.
Okay, and there's this deemed selling price that it's all done at fair market value. So an example you could use is you have a pensioner who dies on January 30th.
Okay.
Okay, so for the month of January they earned an income. So with their pension, whatever that pension is, they probably received some CPP. They may have received some OAS with that, so that they'll get issued a T4 for that. T4, whatever it is, when it comes from pensions. Okay,
Yeah.
if they have a house, then it's deemed to be sold at fair market value. But if they lived in the house, not a big deal, because your primary residence under the tax code is exempt capital gains.
Right.
Good. So that's all money that's going to the beneficiaries, no tax benefit. If the person who died also has a bunch of RIFs, let's say $200,000 in RIFs,
Yeah.
well, that's now brought into income because the RIF collapses. So that pensioner, they got a pension of, $3,500 for the month of January. They got another $700 from CPP and maybe $200 from OAS. I'm making those numbers up. And then they have $200,000 added to the income because of the collapsed RIF.
Right.
Right. So now they're when they do their income tax the following year, for the year that they passed, that person's income will be $200,000 and about $4,000, whatever the math works out to, what I said earlier.
Right.
If they also owned a cottage, or they owned revenue property or other property that is not principal residence, then that triggers a capital gains.
Right.
So that capital gain will also be added to the income. So there will be taxes on that. So there is a tax event. There's no death tax in Canada, but it's whatever it is, whatever you own is collapsed if it's registered accounts, and it's brought into income. And if you own property, it's deemed to have been sold at its fair market value, which triggers tax.
Right.
So there's not an additional tax. These are all taxes you would have had to pay.
It's just that tax has to come out of the estate before it's like given to the beneficiaries.
Correct.
So sometimes there can be timing there, like maybe don't give it all away.
No.
Months later.
No, do not give it all away. That's a terrible idea. Yeah.
I like to bring that up because I know circumstances where the executor basically had to ask for money back to pay the taxes.
Yes. Yeah, we're always very when we're dealing with our estate clients, we're always very clear. You do not because your primary responsibility as an executor is towards the creditors first,
right?
Not the beneficiaries,
right?
So you have to pay off all your creditors, and of course, Revenue Canada is probably the biggest creditor for most people. So you have to pay your creditors first. Awesome. Because it's only after all the debts are paid that you have an estate, that you have the residue.
Right.
So their primary responsibility is towards the creditors. So I always tell my clients, before you spend any money in any of this distribute, talk to the accountant first.
Right.
You want to talk to a chartered professional accountant because they have insurance. If they give you bad advice, their insurance will pay to fix that. Right. So even if it costs more money, get a CPA, get their advice, say, okay, here's all the information. What do you estimate the taxes to be? And then it'll give you an idea of what it is. Then you would keep that in reserve or pay it.
Yeah.
And then you would keep an additional amount in reserve just in case.
Right.
And then you could do an initial distribution at that point of the money. And then once the taxes are all paid, the executor would apply to Revenue Canada for a clearance certificate, and they can get their CPA to help them with that. And once they receive the clearance certificate, that's their get out of jail free card.
Oh, nice.
Right. So then Revenue Canada cannot go to them anymore and say, oh, you know what, we made a mistake, or we reassessed more taxes as owing. That you could just say, I got my clearance certificate. So, bugger off.
Right. That's awesome. Okay, so let's see where else am I in my notes. Okay, so in a POA or estate sale, what happens if no one knows anything about the house? I might talk more about that.
You mean the person selling it?
Yeah, the person selling it.
Yeah,
So
yeah. So the POA. So let's say it's a long lost relative. They didn't know they were appointed as POA, and the person who's now incompetent or who has passed, it was a recluse living in the and maybe a bit of a hoarder, and then all of a sudden this person who hasn't talked to Uncle Frank in 15 years realizes he's the executor. Uh, all right. So he comes into Winnipeg and he tries to sell a house. He doesn't know anything about the house. We're still using the property disclosure form in most realtors. You do not want to complete a property disclosure form in that case because
that's
you're
right.
making warranties and or promises, not warranties and reps, but you are making representations about the house. If you know nothing about the house, you have no business doing that. All you are asking for is trouble.
Yes. We're also
Lots of it.
probably going to look at the new offer and cross out a whole bunch of section 9 and cross it out, exclude it.
Yeah.
But
Yeah.
yeah.
Yeah. Section 9 is an issue, I think, in the new offers. As a lawyer, I don't particularly like them.
No, I know
That
they've
section.
added in a lot more risk for sellers and a lot more protection for buyers. And,
Yeah.
if you're working for the buyer, that's great. But when you're working for the seller,
Well, it changes the long established law in Manitoba and in many common law jurisdictions of buyer beware, right?
right? Yeah.
And there was a reason why buyer beware was in place. It's like if you're a seller and you think you're going to be on the hook for stuff, what do you do with the sale proceeds? Like you don't necessarily want to spend it all because you might need it in case you need to go back and give money back because you've made these representations and you thought everything was fine, but now all of a sudden you're on the hook for something.
Right, exactly. Yeah, it definitely is causing a lot more conversation during the listing presentation about what promises we are making in that new offer and how much do you actually know and like can say, yeah, I haven't had water in my basement, but it also has been completely finished the entire time I owned it. So how do I know what's happening behind those walls? Right? Like,
Well, and it's not even that. I think about your house that I don't know how long you've been living there, but there are things that happened 10 years ago in our condo that I have no memory of.
absolutely, yeah.
Right.
And it's no longer to the best of your knowledge. I mean, it's never been to the best of our memory. It's always been to the best of our knowledge. But now it's not even that. It's a yes or no. I promise or I don't.
Yeah. Yeah.
Right?
There are pretty significant representations made in
Yeah.
this one. So I'm not super keen on that, but we'll see how that's probably where you're going to see litigation develop in the with the new offers is in those warranties and reps.
Yeah. So then I always like to have that conversation about like, what does that mean to sell the property as is? And we typically do in an estate or a POA situation, we call it an as is because that POA can't be making represented. Like, even if I was to sell my dad's house, who, he's lived in that house since 1997, I never lived in it, but do I really know enough about his house and what he's done to his house to confidently answer questions and to have section 9 be standing? And whereas I feel like there are some questions. I know he did a big renovation. I know he pulled permits. I know he right, like I can answer some questions. I know before he retired he did the shingles. I know he did the furnace. I know, right? Like I could probably find the receipts for that. But can I really, like, I'm not the one using the sink and the dishwasher and the furnace, right? So, to be able to say everything's in working order, and the 9G is in proper working order, right? So like, it's also very subjective.
Specific, yeah.
And so to even though I have knowledge on that house, I would still think I would have to put as is condition because I don't have definitive, I'm not using the things in the house on a consistent basis to know that I can say, yes, everything's working, everything's, I didn't do hire all the people that did the work. I can't say that every permit has been pulled. I know he did permits for the big renovation, but maybe he did some wiring in the basement because he is a nice little do-it-yourselfer, right?
Right. Yeah.
And so, like to make the promises that the offer has us making, right? But the downside to just switching to as is it can affect your market value.
Yeah, I know. I'm a lawyer, and until I know what all of these representations and warranties actually mean, and that's going to take years because
Absolutely.
litigation always takes a long time for these things to develop. Because
Yeah.
I don't know what the impact of all of this is going to be long term, right? And the judges are going, in the courts, they're going to have to interpret these contracts and give
Yeah.
meaning to them and legal, and that's going to take a while. That's
It's
going
going
to
to take a while.
probably,
Right now, it
yeah.
just sounds really scary the way it's worded.
Yeah. And until if I had to sell a property right now, I'd probably, even if it was my own property, I'm a lawyer, right?
Yeah,
So I do that
that's
anyway.
right.
As is, you get
I
what
know.
you get. If you're not happy, go somewhere else. Now, I know as a seller, it's not always easy to do that
Yeah.
because you're in a market. I think it's easier for lawyers to do that because the realtor can just say, "Ah, he's a lawyer," and people will just say, "Oh, okay, yeah, I get it." Right?
Yes, I have sold
I
for
can.
lawyers that have put that, and I'm like, well, he's a lawyer. He's not going to promise anything.
Yeah, yeah. So,
Yeah.
yeah, and I think most people accept that
Yeah.
as okay, where they may not feel confident enough
Right.
to do that. But
Yeah.
I would probably, I know for sure Cheryl, my spouse, would put as is.
Yeah.
Yeah, she's no nonsense once it
Yeah.
comes to that stuff.
Yeah.
But yeah, I would likely, or I would, if there were limitations, I would be very clear about our representations. I'd be very clear about what they are and what limitations I'm imposing on them.
Right.
Because I was, Cheryl does a lot of. I used to do commercial work too, and Cheryl does a lot of commercial work. And warranties and reps in commercial deals are a big deal.
Yeah.
And we often argue about in negotiations. We often argue about those warranties and reps, the extents of which, how long they last.
Right.
We put a date and time on them, right? And
Yeah.
2 years. It used to be 2 years. Now it's like 18 months, 12 months. We don't
Oh,
like
yeah.
warranties and reps.
Yeah.
When we're acting for a vendor. When we're acting for a buyer, we want as many
We
warranties and
want
reps
to
as we
add
can
as
get.
much as we can. Yeah.
So the warranty and rep world
Yeah.
is, on the commercial side of things has been a world we've lived in for a long time, and we're quite used to it. Having these warranties and reps standard printed into the offers to purchase, I think that's going to create problems.
Yeah. I know that's been the general consensus, and a lot of our talks about when we're talking about just the offer is how to protect our sellers and still keep some protection for our buyers, because
Yeah.
most of us work with both, not just one or the other, right? So it's hard to say that we hate it when it is good for our buyers, because in the past, especially on years like this where the bidding wars are so crazy, it's hard to get like things like an inspection included.
Yeah.
Right. And then
Yeah.
so it's nice to have some sort of protection for the buyer. But yeah. So we could talk about that part all day.
Yes, yes, we could.
But another question I had actually recently came up because I was doing a CMA for someone who needed value for probate, and she's like, "Well, because the market is so crazy this year, what happens if the property does sell for more or less than the probate value?"
Yeah, and that's okay because so the reason you're asking that is because when we make an application for probate, we have to include the value of the assets of the deceased as of the day that they passed,
Right.
So that's the date of what the fair market value is. If you're in a really volatile market and the house sells for more or less than that, that's fine because the market has changed, right? It doesn't affect the fact that on the date of passing, the fair market value of the property was that. Now, fair market value is there's a lot of subjective judgment in there, right? It's hard to determine that, from a realtor. I used to do it. You take comparables, but yeah, that'll give you a range.
That's right.
Right, at best. You're not going to get, the house is worth 564,083,
Yeah.
it's not going to, it's worth between 5 and 525.
Yeah.
Is probably kind of the range so you kind of pick a number in there. And that's okay. That's fair market value. Like it's the law doesn't require you to be exact when it comes to fair market value. It requires you to be reasonable.
Right.
If 6 months later you sell it for a lot more or a lot less, then that's just the market changed.
Yes. I also, talked to her about how like market changes, but also condition changes, right? Like, because when we're valuing it the day of passing, we're valuing it on today's condition. So like in some situations, maybe it's a hoarder house, maybe it's it's just been so much deferred maintenance, and then as you're emptying it, you're doing things that improve the property, right?
Yeah.
So yeah, the property could then sell for much more money, just after cleaning it up, right?
Yeah, for sure. Yeah, absolutely. Those are different values at different points in time under different conditions. So it's fine as long their obligation, because they're signing the application is like an affidavit, so you're making a declaration that to being the best of your knowledge.
Right.
It's reasonable for the executor to rely on a realtor's CMA or two realtors CMA, competitive market analysis. I think CMA stands for.
Yeah, that's right.
Yeah. So that's what they need to do. They need to make a decision based on a reasonable it has to be a reasonable basis, right? And having the two CMAs that come in about the same, taking the average of the two, they're completing, they're observing and respecting their declaration.
Right. Yeah. It's just a common question I get. That's why I thought I'd ask that. So where else are we? We already talked about timing. Sorry, I some of my questions you've already answered, so I'm like, we might as well not go over them again.
I'm too chatty.
No, that's okay. It's good. I just kind of make notes so that we don't like miss something, right? Like, and then I typically don't ask everything I put on my notes, because often we have discussions that flip back and forth around these topics. What are some of the biggest mistakes you see executors or families make in these situations?
I don't know if I say there's a lot of mistakes. I think, executors tend to be very careful, right? Because they take the job seriously, and it is a serious job to take, right? So that's not an issue. The kind of things that we see are more in terms of dynamics between the beneficiaries, I think, is an issue. And I wouldn't say that's a mistake anybody makes. I think that's just the reality they live with.
Emotions usually.
Yeah. Well, there's nothing like the passing of a parent to inflame already existing tensions between siblings.
Yes.
It gets a lot. It explodes, right? And it's really unfortunate. And I always tell my testator clients, the people who are making the wills, to make sure that you're clear to everybody in your family about what your wishes are.
Yeah.
Because unmet expectations often arises. Somebody thinks they should have been the executor, somebody else is. People going into the house, right away and starting to take things that before the executors, the other siblings have had a chance to get in there.
Yeah.
Like there's a lot of really hurt feelings and emotion, understandably, around these things. So that often enough comes up. I'm not going to, a lot of times everybody gets along, but when they don't, if you have a sibling that's kind of a bit of a troublemaker or they feel a bit entitled, then they go in and they start taking stuff. So maybe one of the things they should do is executors, when there's real property involved, is securing the real property.
Right.
Like getting in there quickly, changing locks if necessary, but that's hard, right? Because
it is hard.
You don't want to tell your siblings they're not allowed to go into the house, because that might inflame the situation even further. Right. So they really have to use their judgment and their knowledge of the family dynamics to try to navigate that. And I always tell people, just get through it. Even if it's not ideal, even if it's not perfect, but just get through it.
Yeah. Yeah. And I always remind people that, these are the people that installed our buttons. They know how to press them.
Yeah, that's right. That's right. That's well said. I might borrow that, actually.
Yeah. They're the ones that put them there. But so yes, this can be one of the hardest things we do in our lives, right? Is deal with these situations,
Yeah.
especially when involving our siblings. Um, yeah, dealing with. I love my siblings, but I can't imagine the day that we have to deal with all that.
Yeah. Yeah. Exactly. Yeah.
Yeah, yeah. I know we all have very different opinions on things, so
Mhm. And that'll usually come out.
yeah, exactly. And yeah, so to me, yeah, you're right. Probably not biggest mistakes, but yeah, like having to try to navigate all the emotions and differing opinions, right?
Yeah. Yeah.
Um,
You have to be diplomatic. You have to be reasonable. You have to be objective when you're doing that because it's a job. When you're an executive, you've got a role to play. You got to complete the job.
yeah,
And if you get sucked into the emotional side, it's just going to make your job much longer and more miserable.
exactly. Um, so yeah, my next question was going to be what causes the most stress, but that probably was it. Um,
Yeah.
and um, yeah, so yeah, and that one's about emotions. Okay. Apparently, I asked a lot of the same questions. When should someone involve a lawyer and a realtor or other professionals in the process?
Um, so when somebody passes, there's no rush to find the will right away and to get things done. When somebody passes, that's family time. That's time to remember the deceased. That's time to take care of the funeral. That's time to get family together, to remember the person that you've lost, and just to be together. It's a time to mourn,
Yeah,
right? And that time should be taken for that. There shouldn't be a feeling that they need to move on to the next stage right away. The focus really should be on the family side and the human side of this. Once things settle down and the executor is kind of ready to move, that shouldn't be too long, but like, even if it's a couple of months. I mean,
right,
you have a house that's vacant, so that's not ideal either, right? Somebody needs to keep an eye on the house. You need to advise the insurance company, right? And then there's further obligations on the executor at that point to make sure, because insurance companies don't like vacant houses,
right.
right? You have to be in the house a couple times a week. So you have to make sure that those kind of things are in place. And then you take your will, the original documents, and then you should be making an appointment with the lawyer. It's probably not a bad idea to touch base with the realtor at that point either, just to give them a heads up if there's somebody that like a friend of the family or a realtor that you normally work with. If you don't work with a realtor and you don't know anybody, then maybe it's not necessary to talk to them right away. But the when you're putting together the application, you need a fair market value of the house. Oftentimes, that's where realtors can come in because they can provide a competitive market analysis. We often use the assessed value at the city, which isn't always accurate, but it's reasonable in most cases for
Sure.
clients to rely on that.
Yeah,
And then you put the application in, and then and then at the next step, once you get the letters of probate, that's when the realtors will be needed for if the goal is to sell the property.
right. That's awesome. Yeah. Um, if someone listening is about to go through all this, what would you suggest their first step be?
So you need to be. I need more context to your question here.
I
So
know I'm like that's so vague. If someone just had someone pass away and they know that, or maybe we're in a POA situation, um, yeah, I don't know. That's too broad. Let's skip that.
it would be the same considerations as if you were selling your own property, right?
Yeah,
You need to get the property in order. You need to talk to the realtor. It's good to talk to the realtor in advance because they can give you a lot of advice on how to stage and get ready. If the realtor might be able to flag a couple of legal issues and then say you need to talk to your lawyer
yeah,
about those kind of things. So
yeah.
if
I
you're
like
if you're acting under a power of attorney, it's probably a good idea to get the power of attorney looked at by the lawyer who's going to be acting.
That's exactly
Uh,
what I was going to say. I like to chat with them early so that I can look at the power of attorney and make sure that it actually allows for real estate,
yeah,
right? And if something needs to be, you know, addressed in that situation.
yeah, because there are things that have, like, there's the Homestead Act that has a role to play in here.
Right.
There's also, like, what does the power of attorney look like? Is it an enduring power of attorney? Does it have the mental infirmity clause? Like, there are those kind of things, because the property registry will inspect the power of attorney. Because if we're selling a property under a power of attorney, we have to send a copy of the power of attorney with it so that they can take a look
Exactly.
at it.
Yeah.
Yeah. So if you are selling under a power of attorney, before you enter into contracts, you should probably have your power of attorney reviewed by the lawyer who's going to help you with the real estate transaction.
Yes. And even your realtor needs a copy of it, as well as, an executor acting for an estate. We need a copy of all that. Like, it's part of our job to confirm that you have the legal right to be selling property.
Right.
So, typically I'm IDing someone with their ID, and I match it to the title. And if you don't match, then I need other documents to say, why are you selling this property? Right. So, it's not just call and get the listing put up. And we do it.
When I sold real estate back in the 80s, it was like that. It was just sign here. Let's get it up.
Now title fraud is massive, especially like out west and in Toronto. So now, like, our requirements from, like, our FinTrack requirements and our duty to like ensure that we're selling, a property that is actually owned by, like, that's one of the reasons to hire a realtor versus as a buyer versus going at it alone, is to make sure that you're buying a house that someone actually could be selling. Right?
Yeah, that somebody's entitled to sell.
Yeah, especially with Facebook Marketplace being the way it is, right? Like, you have no idea what's on there, and if they're actually, allowed to be selling what they're selling.
Yeah, and we had a case in Manitoba not all that long ago where somebody was taking. It was a weird situation. We didn't even understand why the person was doing this, but they were fraudulently taking title.
Yeah, we've also seen a lot of the rental scam where they're taking deposits. Yeah, I've seen a lot of that, and they're often using realtors' pictures to advertise a house for rent, and then taking deposits and then ghosting the people. Yeah, so you got to be careful who you're dealing with, for sure. What is one thing most people don't know about estate or POA sales that they should?
I don't know if there's one thing. I think we kind of covered most of that.
Covered all the things.
Yeah. I think just that the documents are in order. The legal documents are in order. So the grant of probate is proper and was issued by the court. The letters of administration have been properly issued. The POA is a valid POA that gives the authority for the attorney to do the things that they're trying to do.
Right.
Like those are important aspects. Now, those should have all been done by the lawyer who drafted those things, but the lawyer who's involved with doing the transfer of the documents, they also need to review these things. So
yeah, I know I get a little more, I'll say, anxious. I don't know what the right word is, when it's like when they're using like the documents that they find online, right? Like, it's a lot harder for me to know, like, then I'm like, yes, let's have a lawyer look at this and make sure that we can actually use these documents, because some of them aren't for our jurisdiction, right? Like, if you're using a self-made package,
yes.
Like,
those are often problematic.
Yeah, exactly. So I know, like, it saves you some money on the front end, but how much heartache can it cause on the back end, right?
Yep, absolutely.
Yeah. But yeah, so, well, thank you so much for taking the time. I'm sorry I took up a lot of your time.
No, I'm happy to do it.
And I really appreciate it. And I think we've answered everything we can answer about this topic in as general as we can. And for anyone who is about to go through this, like, specific situations require us to, address that specifically. And, you can call Philippe's office if you're looking for a lawyer for that type of stuff. And I'm also available to answer what I can. I stay in my lane though. I am the realtor, and stuff that needs to be answered by a lawyer, you need to talk to a lawyer.
Yeah, and stuff you need answered by a realtor, you need to talk to a realtor,
Right.
That goes both ways. You and
Yeah,
I,
yeah.
we both need to stay in our lanes.
Yeah, exactly.
Wow.
So, but yeah, so give us a shout. I'll put our information in the description. And thanks again for coming on. And if anyone found this helpful, please like, share, and subscribe. And thanks for listening.
Yeah.
See you again.
We'll see you in the next one.
Yeah.